and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Just before I introduce David Whiting and his homework, just to follow up on the subdivision, I love a good little bit of local language. Mark's got this on subdivisions. Apparently, according to Mark, Geelong's a haven for subdivisions, and there's a local colloquialism, battle axe it. Battle axe it. So could Geelong Council regulations provide a pathway for Infrastructure Victoria? I love a good little bit of local language. If you battle axe it, you're subdividing your suburban block. If you've got a query for David Whiting, he's a Melbourne solicitor. He's so much more. He's so much more. David, good morning.
Good morning, Raph.
Your homework? Do you want to take us through?
I did oodles of homework.
You did.
So we'll rip through it. Ali from Hampton has some Norfolk Island trees in the nature strip around her property, and their fibres create some health issues for the people living in the house. Can we make the council do anything? The answer is no, but the council can if it wants to. The council has power under the Road Management Act, but it's only in circumstance, without doing anything other than just go and cut the tree, but only where it's necessary to remove a danger to road users. Uh-huh. The focus is road users, not neighbours. But look, they manage the nature strip. They can. I would be trying to get some evidence which would indicate that the trees are harmful to people. And then if I couldn't get what I wanted from council, I'd be talking to the Ombudsman to see if there could be a statewide strategy that deals with the issue.
Oof.
Ombudsman's fantastic.
Oh, sure, just not a very short-term solution.
Oh, no, there's no short-term solution.
Yep.
Well, none that are legal, so let's leave it there.
Understood.
Grant from Wattle Glen. Mum has a disability, living in a block of units, and we're worried about disability access for Mum. They want to put in what amounts to a row of bricks to change the step level, and wants to put in a safety rail, which I think is fantastic. Note that Mum's a tenant, not an owner. Now, the difficulty is that everything that the body corporate manager is doing, which looks like horribly obstructive, is technically what the owner's corporation manager is required to do, because what Grant wants to do for his mum is get a lease of common property. They want to be able to do what they want to do on that part of the common property, which is outside Mum's unit. Now, if we were looking at this remarkably risk-averse society in which we live, you would want an occupational health and safety assessment. You would want some engineering drawings, and you'd want to involve your insurer, and you would want a special resolution of the owner's corporation. That's technically, to lease part of the common property, lease or license part of the common property requires a special resolution.
Gosh.
And then to put it to the owner's corporation, it would be prudent to provide all of that other rubbish.
So it needs some real charm maybe to
yes,
avoid
they do.
some of the
what
paperwork.
You really want is a nod, wink arrangement. Just put them down and see what happens. Yep.
That's your formal legal advice from ABC Radio. Okay, David
and
Whiting.
Finally.
Oh, sorry, you had one more.
Finally wasn't a question for homework, but it was something I took on. Sam from Ocean Grove, who was concerned about the number of data breaches that we've had, and I think we've even had one since we met a week ago. And the issue there is I can simply refer him as a really good starting point to a website called idcare.org, which is substantially funded by the finance industry in Australia. And it's not the answer, it's not the panacea for everything, but it's an awfully good start. Thank you.
Thank you very much, David. He's very good at his homework, and he does it all before dinner time as well. Alison is in Donvale. Alison, what's your query?
Yes, good morning. Good morning, David. Yes, I want to know if I have any legal recourse on an investment property I bought 3 years ago. The apartment building was issued with a building notice in 2018. However, it wasn't declared in the Section 32 when I purchased it in 2020.
Why was it? Did you buy it from the developer? Or
No, I didn't.
Did you buy it from a private person? So you've got to look and see who your claim is against.
Yep.
Your claim, you don't have a claim against the vendor because the vendor isn't stuck with those deceptive and misleading conduct allegations because they're not a trader. So no for the vendor. You may have a claim against the owners corporation if the notice is addressed to the building.
Okay.
Right? Because it should have been declared in the material from the owners corporation.
Right. Well,
Right,
that's
so have a look at the Section 150 certificate and attached documents and see where you go from there.
Yeah. The interesting part is that the owners corporation weren't approached for any kind of Section 32 information. So they weren't.
Can I say, Alison, in the nicest possible way, more fool you.
Yeah, I know.
The Sale of Land Act says that if the vendor does not provide you the required information in respect of an owners corporation, where there is one, you can walk at any instant up till settlement.
Yeah.
So I'm really very sorry. The owners corporation might have provided it, but you have to ask them and you've got to pay them their fee.
Good luck, Alison. Thank you. Elaine has called from Rosebud. What do you want to raise, Elaine?
Oh, good morning. Thank you for taking my call. I've had an accident in October of 2022 and I had third-party comprehensive insurance and that was all paid out and I've got a new car. And on Saturday, I was issued with a summons for the Magistrates Court, and this person that I hit is suing me for his damages, and yet in the summary of it seems that he has
we just lost her. Hold on a tick, Elaine. I'm going to ask you to repeat that.
A couple of questions, if I can.
Yeah.
Is it a claim for damage to the other person's car, or is it a claim for personal injuries?
No damage to his car. Nobody was hurt.
Then you refer the matter to the insurer. It seems to me as if your insurer has resolved with you, but hasn't resolved with the other driver or the owner of the other car. So give it to your insurer.
Right. Will I be able to employ a lawyer for that? Or
no, your insurer will take over the conduct of it for you. But if it's a summons to the Magistrates Court, is it a summons to give evidence or is it a summons asking you to pay money?
Asking me, I'm an 80-year-old lady and they're asking me to pay $26,000.
Okay, give it to your insurer, Elaine, and make sure that your insurer is going to respond, all right?
Okay, thank you very much.
Thank you, Elaine.
Good luck, Elaine. I can hear how distressed you are about that. I hope your insurer does make that easy and simple for you. Andrew is in Parkdale. What do you want to ask, Andrew?
Good morning, David. I've got an owners corporation final fee notice in front of me for the fees for the owners corporation, which includes 2 lots of $55 late fee charges for invoices that we didn't receive for 5 months. And my question is, can you be charged a late fee for an invoice that you did not receive despite numerous contact with
the question's slightly different, Andrew. I mean, if it was a defence for not having received it, no one would ever pay a late fee. The real question, there are 2 questions that arise. The first is, was it actually sent? And was it sent in the way that you had reached an agreement with the Owners Corporation manager or in accordance with the Owners Corporation rules, is the first one. And the second one, and I've found this to be quite helpful, what you want is a copy of the annual general meeting minutes which fixes the late payment fee. Because I found in a couple of instances there's been a general discussion about the late payment fee, but no resolved minute for a note. So in a sense, there's been no declaration of the charge.
So it's not a fixed thing unless everyone agrees.
Well, there needs to be a resolution of the Owners Corporation agreeing to the fee. Otherwise, they can't charge it.
Does that help?
I'll look at the fine print, but is there a any basic principle that if you don't receive the notice, the invoice, that you shouldn't pay the late fee?
No.
If it was there, so that's not correct.
No. It's. I mean, let's. I don't know. Let's say you went to London for 3 months and it came while you were away. Your argument would be you never received it. The question is really, was it sent, and was it sent to the right address and in the right way? And if that's the case, the fact that you didn't get it is really got something to do, I think, with the way you choose to receive them. If you get it by email, look in your spam folder and see if it's there.
No, we never received it. We contacted them numerous times by mail and by email and by phone, and still never received it.
Well, then why don't you make the waiving of your fees a matter for the next annual general meeting and irritate everybody? Okay.
Good luck, Andrew. Thank you. People are in real pickles, aren't they? Patricia, you're in North Brighton. What's your query?
Hi. Hi to both of you. David, a couple of weeks ago, I heard you talk about unreasonable water flow. I bought an apartment a couple of years ago, and my bedroom is getting to the point where it's virtually unlivable. And I've only got one bedroom.
Yes.
And there's 3 apartments in that are also having water flow, and it's all coming from the top apartment's balcony. And we've tried to approach the builder over a period of time, but he's now gone to ground. We can't find him. And I'm wondering if we're eligible for unreasonable water flow.
Seems like you're already getting it, Patricia. You can't make that law.
Eligible for a claim for
Look,
unreasonable water
Patricia,
flow.
Yes, exactly.
You've actually got to find out. You know what the proximate cause is. It's from the balcony above you, but you need to work out, you need to actually find out where it's coming from. Now, a couple of years ago, I was involved in a similar dispute relating to a block of units in Port Melbourne, and the suggestion was that the water was coming from my client's balcony onto the unit downstairs. But we were actually able to work out that it was coming down from the roof inside the wall and affecting the downstairs unit. So, yes, you do have a claim to, so you all have what sounds like the same claim, and you should run it together. Your issue is the unreasonable flow of water, because there shouldn't be a flow of water from the balcony above into your living space. The matter goes to VCAT, but I would be taking it up with the Owners Corporation. How old is the block of units, Patricia?
It will be 6 years old in October.
Then you might also, it then becomes a question of who has the right to claim the owner on the owner's guarantee, because it's probably not the Owners Corporation.
Right.
There's a gap in the system about who gets to claim.
Oh, my God.
Who has the benefit of the builder's guarantee, and generally it's not the Owners Corporation.
Oh, okay.
Mm-hmm.
All right.
Good luck. Good luck, Patricia.
Thank you so much.
It's 19 minutes after 10. So Eliza's texting, the ABC's taught me a lot of things over the years, but the number one lesson remains: don't buy anywhere with an Owners Corporation. We are getting a few questions in that particular area.
My view of Owners Corporations is that you want the cheapest one you possibly can. You want the maximum level of service,
yes,
but you want it for the cheapest. I mean, it's like saying, I choose to move municipalities because the rates are lower in X or Y. No, doesn't do it for me.
Doesn't work. Ken is in South Yarra. Ken, what's your issue?
Good morning, everyone. We have 4 visitors' car parks on our property, and every so often someone parks there and just leaves their car, as someone has done recently, at least a month ago. They put the tarpaulin over it so it wouldn't get any possum poo on it. I'm just working through the process so that we have a legal position in the future to ensure that we can tow the vehicle away. We don't have such signs at the moment, but I'm going to engage a towing contractor to talk about what to do. But I also understand, David, we need to set up some model rules which are would help us to enforce any.
Ken, you already have model rules. You're looking at changes to the standard rules. You may recall, 15 years ago, there were lots of issues where people started impounding vehicles that were parked on their lot, and then I'll charge you a release fee.
Yeah.
And that became an incredible consternation, so be really careful about doing that. Your issue is that you need to be able to work out if you've got a cause of action against the person who parked it there. Question is, how do you find that person?
We've been to the police to ask them to contact the person to say it's illegally parked.
Yes.
Obviously, we can't get any other information.
You can. There's a process for issuing proceedings in the Magistrates Court for Vic Roads to give you the identity of the owner of the vehicle. It's a fairly simple and straightforward process. And what you might choose to do is apply for an injunction. Step it out, but first of all, don't move the damn car. But if necessary, apply for an injunction to prevent them parking there at all. Right? And ask for costs as part of the process. It will cost you some money, but it will get rid of the car for you. I mean, there are other people who would suggest, and I can't because it's probably illegal, is to push the car out onto the street and make it someone else's problem. But you just can't do that, Ken. So the process is...
We're not intending to do that.
Good. Then the process is Vic Roads, because Vic Roads can be compelled by a court order to identify the owner of the vehicle, or sorry, not the owner, the operator of the vehicle, and then have an action against that person.
Good luck, Ken. David, generally, if someone's parked in my driveway, I can pull the car out, can't I? Or what if I own the block of 4 units, but I don't live in the other 3 units?
Yes.
Surely I can pull the car away if it's not parked by someone who lives there. Don't I get to pull it away?
Provided you're not going to damage it. And then the question would be, if you parked it somewhere it got illegal or was illegally parked or a clearway, are you creating a problem for them for which I might have a go at you?
What if you just parked it on the street and they just got the fine for being over the 2-hour limit or something?
I think that happens lots.
It does happen a lot, does it? Right. So there's nothing actually stopping you moving the car. If your property, the issue is whether or not you endanger it or
property
damage
that's shared, I've got no difficulty with that.
Yeah.
Just make sure you don't cause any damage to it as part of the process.
But mind you, that's an expensive thing too.
Yes.
Those car lifts can't be cheap. 23 minutes after 10. Ken, good luck with that. Let's go to a fence issue. Brian's got one of those in Croydon. Brian, what's your particular query?
Oh, good morning, guys. Thanks for the call. For 2 years, we've been trying to get our...
Brian, could you get a bit closer to the phone?
That's it. Get off speaker.
Yeah.
Great, Brian. Thank
How's
you.
that?
Yep, better.
How's that?
Perfect.
For 2 years, we've been trying to get our side fence replaced. We've now got to the stage where we've got the front third replaced, the rear third replaced with new fencing, and the middle third needs to be replaced. I've given a notice to fence to our neighbour, and they've come back and said no, they don't think it needs to be replaced. It can just be fixed.
Yes.
If we pay to get the fence replaced, is there any issues with our neighbour?
Well, you can only do fencing work with your neighbour's agreement or a court order. So if I was next door to you and you wanted to replace the fence and I agreed with the fencing, I'd be delighted if you paid for it.
Right.
So why don't you make that approach? I think it needs replacing. I'm happy to pay for it because it'll be cheaper to pay for it than run an argument in the Magistrates Court as to who's going to pay.
Yep.
And we're only talking about a third of the length, not all of it.
Yep.
So what you want to do is get your neighbour to agree to you replacing the existing fence with a fence that matches this description.
Terrific.
Okay.
Alrighty. Thank you very much.
Good luck.
You've answered my question.
Thanks.
Good luck, Brian. Good luck. Rachel is in Berwick. Rachel, what's your query?
Hello, gentlemen. Just a quick one. An adult child who was not dependent on...
Rachel, I'm going to put you on hold. I'm just sorry, that phone line's really, really very ropey. I'll see if I can come back to you, but I'm sorry, that reception's pretty difficult. Al is in Reservoir. Al, what's your query?
Hi, I'm helping a relative with a matter. He's got a caveat on his property which he's trying to sell, and he's been trying to resolve the caveat with caveat for the last couple of years now.
Al, I don't want to know who the caveator is, but I want to know what's the claim being made by the caveator.
Right. The claim is that there was a deposit paid on the property.
So your friend entered into a contract to sell the property, a deposit was paid, and then for whatever reason the contract fell over.
Correct. And this is quite an old matter, so the dispute now is over the settlement amount. and it looks like it's going to have to go to court. My friend's been given a cost agreement for close to $100,000 to resolve the matter, which he doesn't have. So my question is, this is an old one, but what happens if the caveat passes away? Does the matter just disappear, or is that
if the person who lodges the caveat
estate?
dies, the argument continues for the benefit of their estate?
Right. Okay.
All right. So
Okay.
the bit that's got me concerned is that your friend appears to be agreeing to, acknowledging an obligation to pay the other person some money. Now, in the normal course, if RAF was to sell a property to me and I defaulted after having lodged a caveat, RAF could make an application to the land registry for the caveat to be removed on the basis that the interest I was claiming as purchaser under contract of sale didn't exist anymore. All right?
Correct.
Now that's the process, but what you're putting to me is that your friend is acknowledging that I have to give this person some money, so it may be that they do have a caveatable interest. Don't know.
Yes, and so to resolve it, we're looking at we don't seem to be able to resolve it through out-of-court mediation, and in-court mediation.
Do you have a view about the value of the caveat, El? Don't tell me, but do you have a view?
Yes, I have a view.
So why would you not? I've actually run a couple of cases where you say to the court that upon settlement you will place a certain amount of money in a trust account and the caveat gets lifted. So we have a fight about the amount of the money and nothing else. Right. Now, at the moment your purchaser is saying, or your caveator is saying, give me this amount of money or I won't. What that might be that you put that amount of money into a trust account and you have the fight over the money, not over the property.
Yeah, that the money is the trouble. The solicitors have been quite difficult to come to a resolution.
That's okay. Well, it's just because they won't agree with you. So I do think that I would be having that discussion before I issued proceedings about whether it's possible to park some money and then have that argument.
And let's go to Rachel. Good luck with that, Al. We'll go back to Rachel in Berwick. Hopefully you're in a better spot, Rachel. What's your query?
Yeah, I have. Hi. That's an adult child that was not dependent on one of my parents who just died last August. What are my obligations in as far as signing the form from the trustees of my mother's superannuation? Am I obliged to sign it legally?
Are you an adult child?
Yes.
And your mother was a member of a public superannuation fund?
I believe so.
You could probably tell from the crowd who gave you the letter. And they're asking you to agree to the payment of the superannuation in a particular way. Is that right?
They're asking me to sign or to declare whether I wish to make a claim or not on the superannuation.
Yep. You don't have to sign that if you don't want to.
Okay, so I'm not legally obliged to sign that piece of paper, is
No,
that correct?
it will probably result in a delay of the payment and might require information being requested of other people, but you have no obligation to tell anybody that you don't want the money.
Okay. All right. That clears things up. Thank you very much.
Only for some people, Rachel. Good luck.
Good luck, Rachel. And I'll leave. We'll give the final question to Paul, who's in Red Hill. What's your query, Paul?
Hi, how you going? I'm selling a house on behalf of my father because he's gone into care, and the conveyancer has asked me to provide my father's tax file number because of a capital gains clearance certificate. But my father's been retired for over 20 years.
He will still have a tax file number.
Find it.
He will still have a tax file number. You can apply for a new one, and if you can find the accountant from all those years ago, you might be able to get it that way. The reason why he wanted it is that if a property sells for more than $750,000, the tax office assumes that you're a foreign resident and wants 12.5% of the sale price unless you can prove you're not. So you need to find it, or 12.5% of the sale price will go to the tax office, and you can have it back when you lodge your father's income tax return for the purpose of getting the refund in 6 months' time.
Have you tried the ATO, Paul? Have you asked the tax office for your dad's old...
It just looks very complex, but now that I know I have to do it, I will.
The ATO can help sometimes with old tax file numbers, although you're asking for your father's and not yours, so you might need to get him to sign a form to say it's okay for you to ask.
Yep.
Well, I'm the administrator.
Oh, well, then you'll be able to do it.
Then you will be fine.
Yeah, you'll be able to do it.
Yeah.
Good luck.
Okay, thanks a lot for your help.
Good luck. And final one, David, capital gains would apply on that. Depending
no, it's not capital gains.
It's not about a capital gain?
It is, but it's called a foreign resident capital gains clearance certificate.
Right.
Even if it was Paul's dad's home,
yep.
we have this assumption that you're a foreigner and it's an investment property.
So unless you prove that it's your home and you don't have to pay capital gain.
And then bingo, it just disappears. Sure. And some certificates that I apply for, you get back within seconds.
Right. So that's the clearance certificate. You're just basically proving that it's your home. Capital gain doesn't apply.
I know. Even if capital gains applies, if you're a resident and you're lodging income tax returns, then you get the clearance certificate.
I'm going to ring you next time I have to do something like that. Thank you, David.
Bye.
David Whiting, answering your questions on anything at all. I haven't seen him stumped. Although his homework being stumped, I'm not sure. I've never seen him stumped. Every time I've done this session with him, he's here every Tuesday at 10 o'clock to answer your questions.